I'm Alison Buchanan. I'm with the State Bar Standing Committee on Professional Responsibility and Conduct, also known as COPRAC. My talk is on starting off on the right foot, addressing ethics issues at the outset. So the thing that we'll be talking about for 10 minutes is figuring out how to either avoid red flag clients, document that process, identify correctly who your client is and what the scope of the retention is, making sure that you're managing the relationship throughout, but really at the beginning by having a fee agreement in place that protects you and delineates clearly to your client exactly what you're going to do, what you're not going to do, and what they can expect from the representation, as well as what you expect from them. We'll talk very briefly at the end about how to disengage if everything goes wrong and you're no longer able to represent the client. So first, we'll talk very quickly about identifying red flag clients. When you encounter a new client and they are highly emotional, have been through many lawyers before you, maybe they just don't pass the smell test, something about what you're hearing from them isn't plausible, or they have difficulty with the notion of paying fees, the amount of deposit that you've requested. All of those things can serve as a red flag. It's not necessarily that you aren't going to take on that client, but there are things that, particularly when combined, when there are more than one of those factors, you want to think very seriously about whether you want to take on that new client and what the possible implications in the future are. If you decide not to take on one of these red flag clients, you want to very carefully document your declination. You should do that in writing. An email would be fine, a letter's preferable, but really explaining to the client that they're not going to be your client, that you're not going to be representing them, and that they need to find someone else to represent them. There's a controversy, not really a controversy, but a question about whether you want to be very specific about any pending statutes of limitations or whether you want to be more general about that. One school of thought is that you're best protecting the client by identifying for them what the applicable statute of limitations would be and encouraging them to seek other counsel so that they can make sure that they protect any claims within that statute. The other school of thought is that you're actually exposing yourself to some risk by identifying any specific statute of limitations or time frame, and that it's preferable to reference a general statute of limitations, something to the effect of, we won't be representing you, we encourage you to seek other counsel, you may have claims that are subject to the statute of limitations, and as such, we encourage you to promptly seek other counsel. Another thing that you can communicate in that declination letter is a referral. Sometimes if you decline an engagement, someone will ask you, well then who would you recommend? If it's one of these red flag clients that we've talked about, you may not want to send that person to one of your friends, and in that case it may be safer to refer generally to a state bar organization that has a lawyer referral service or an LRS. In other instances, perhaps it's just not a good match or a good fit, and there are other lawyers that you can think of that might be a better fit for that potential client. In that case, I would encourage you to recommend at least two options. Although it's not a very favored claim nor a very common claim, it is possible to be sued for negligent referral, which you also would want to avoid. Endorsing one specific person by only recommending one person as a way to sort of get yourself into that potential area of trouble. So the fix there would be to recommend at least two other lawyers to that declined client. If you decide to go ahead and take on your new client, you want to specify a couple of things really carefully at the outset, and this will make your life a lot easier and also serve as some risk management protection. And one is to identify who is the client. And there are a couple of instances where that isn't as easy as the sort of simple client comes into your office, you know that's the client, they know you're the lawyer. In cases of closely held corporations where you may have multiple partners, that could be a point of confusion for your potential client, whether it's the corporation or one or more of the partners. In the instance of a startup where there is no actual entity yet that exists, are you representing the founders as they start the startup, and then perhaps once that entity is incorporated or whatever organizational choice you make, then that entity can become your client and the relationship with the individual founders is terminated. It can also come up in personal injury cases, for example, where you represent a personal injury plaintiff. And the spouse may have a loss of consortium claim. It may be that you don't discuss that loss of consortium claim or potential claim with your client or with the client's spouse, and that spouse ends up losing out on that potential loss of consortium claim. So it's very important to clarify in those instances who the client is and who the client is not. Another example, and this comes up quite often, is the estate planning situation where you represent the administrator of a trust who is also the beneficiary of that trust. And it's very important at the very outset to clarify, I'm representing you as the administrator. You may also be a beneficiary, but I don't represent you in that capacity. And making sure you've clarified who is the client will save you a lot of heartache and risk in the long term. Once you've clarified who the client is, you also want to clarify what the scope of the representation is. What you're going to do for the client and what you're not going to do for the client. As a risk manager, I generally disfavor those general scope descriptions. We will handle every legal issue for you under the sun for all time and perpetuity. That's a very dangerous way to perhaps be obligated to provide services that either haven't been communicated to you, that you're not competent or capable of providing, or that just weren't very clear. So if you're going to have a general scope, such as general business advice from time to time, you want to make sure that it includes language that you will confirm in writing each of those individual projects as they arise. And that will help protect you. Documenting any changes to the scope, and that can be simply done by email. We're expanding the scope of our previous engagement agreement of this date to include these additional projects or services. If it's a big project, you probably want to open a separate file and have a separate engagement agreement. And you also want to expressly exclude any areas that are beyond the scope of what you intend to do, and oftentimes that includes excluding tax matters, bankruptcy, insurance coverage issues, and post-judgment proceedings and enforcement and appeal issues. You can also use your fee agreement as a risk management tool where you address things like the client's use of social media, the preservation of evidence, any issues relating to a charging lien. You're obligated by the rules to disclose in writing that you don't have professional liability insurance, what happens with the client file once the relationship has terminated, and then the client responsibilities that we talked about earlier, like keeping you informed, complying with court orders, being truthful, timely paying fees, all of the things that you want to make sure that your client is doing. And of course, if the relationship deteriorates, you've got to withdraw. Under 3-700, you'll have to make a motion for the court. If the client won't agree to your withdrawal, you're very limited in what you can say in your motion to withdraw. California Rule of Court 3.1362 provides those very narrow parameters of basically disclosing very generic information only to the court, no confidential information of the clients, and then of course providing the client's file promptly when the client requests it under Rule 3-700D.